Hello, my name is Attorney Ramsey Bahrawy, and this is Your Money, Your Life. Today our topic is paying for long-term care in a nursing home. First, allow me to warn our viewers that the information provided on this program is for informational purposes only. Given the generality of the information provided, do not act on the information supplied on this program until you have consulted with a competent and experienced elder law attorney. Now on to our program. Our society values safety, it values preparation and good performance. Yet when it comes to preparing an asset protection plan, these concepts are many times thrown to the wind, allowing the pieces to fall randomly. Not wise behavior, as tomorrow is not promised to us. We're all aware that on short notice, storms may intrude into our lives. I'm not talking about hazards such as floods, tornadoes, hurricanes, earthquakes, or tsunamis. Rather, I'm talking about being prepared for issues that arise as we age. Challenges such as senior transportation, elder care, senior housing, management of assets, reverse mortgages, and asset protection planning. Today I'm going to focus on asset protection in the context of Medicaid planning. Let me start by saying that it is important for all of us to recognize that no one knows what the future will bring. No one has a crystal ball. In other words, tomorrow is not promised to you. By the same token, no one wakes up one morning thinking, gee, today I need to establish my asset protection plan. Why asset protection planning, you may ask? It's an age-old question because although asset protection planning is important, historically, people tend to defer this type of planning. This happens despite the fact that the most common concern for a middle-class person is protecting assets in the event of a long-term stay in a nursing home. By now, we all know that long-term nursing home care can completely deplete family assets. Therefore, it is my goal today to educate, motivate, and inspire you to create your asset protection plan sooner rather than later. Let's begin with a general discussion of Medicaid and its asset transfer rules. But first, it is important to understand that Medicaid is a public insurance program for poor people of all ages. It has a stringent set of income and asset guidelines. Often people confuse Medicare with Medicaid. Medicare is health insurance administered by the U.S. government for people 65 or older, or people under 65 with certain disabilities, as well as people of any age with end-stage renal disease. Medicaid is the only U.S. public insurance plan that pays for long-term nursing home care. So let's take a closer look at Medicaid with a brief general discussion of what you need to know. Each state administers its Medicaid program and sets rules for eligibility and benefits within broad federal guidelines. As a result, there may be wide variations in the Medicaid program from state to state. Qualifying for Medicaid benefits is a two-step process. First, the recipient must be screened and determined to be medically in need of long-term nursing care services. The screening is generally initiated by the nursing home. To be medically eligible, an individual must require at least one skilled service daily or must require assistance with at least 3 activities of daily living, including eating, dressing, bathing, transferring in and out of bed, and toileting. At least one of the assisted activities must be a nursing service. If an applicant does not require at least this level of care, Medicaid in Massachusetts, better known as MassHealth, will not pay for his or her nursing home expenses. The second step is qualifying financially. Nursing homes are expensive. However, financial help is available for people with limited incomes, people who spend down their assets, and for veterans. Medicaid recognizes what are called countable assets and non-countable assets. Non-countable assets are exempt from being included when determining Medicaid eligibility. However, elders who give away countable assets or transfer these types of assets for less than fair market value during what's called the look-back period are subject to penalties. The look-back period is a time frame during which the elder's financial history is scrutinized to determine what assets and resources other than Medicaid the individual could draw on to finance health care needs. There are three types of transfers during the look-back that do not affect Medicaid eligibility. They are, first, transfers for fair market value; second, transfers made for a purpose other than to qualify for Medicaid; or third, for the sole benefit of the institutionalized elder spouse or permanently disabled or blind child. The Medicaid regulations were changed by the Deficit and Reduction Act of 2005, which was signed into law by President George W. Bush in February 2006. Prior to the enactment of the Deficit and Reduction Act, the look-back period was 3 years for a transfer to an individual and 5 years for a transfer to a qualifying trust. The Deficit and Reduction Act increased all look-back periods to 60 months, or 5 years. Therefore, the current look-back period is the 60 months immediately prior to the Medicaid application. It applies to all income and all assets. The change in the look-back period means that older adults who have given gifts to family members fewer than 60 months previous to applying for Medicaid may be unable to qualify for benefits. This is called the disqualification period. The Deficit and Reduction Act of 2005 was born of a concern that older adults exploited the Medicaid program by giving away assets and resources to impoverish themselves in order to qualify for Medicaid. Put another way, people were undermining Medicaid's means-based medical assistance program. Consider that someone who enters a nursing home generally has a limited life expectancy. His or her circumstances won't permit that person much of an opportunity to spend money on anything other than nursing home care. Therefore, this person has little, if any, incentive to hold on to assets for future personal use. Moreover, as nursing home care is very expensive, a modest estate faces a looming threat of being exhausted and thereby leaving nothing to loved ones. Accordingly, most people have a substantial incentive to transfer assets to loved ones. It is precisely for that reason that the look-back period exists. The look-back period is intended to prevent people with assets, especially those who have significant assets, from gifting away their assets just before entry into a nursing home. The look-back period establishes penalties that prevent people from making last-minute gifts in order to immediately qualify for Medicaid. To help you better understand, here's an example showing how a penalty is calculated. Let's say an older adult gave away $85,000. Let's also say that the average monthly cost of a nursing home in Massachusetts is $8,500. Simply put, the average cost of the nursing home is divided into the gift. The penalty period usually begins on the date of the Medicaid application. Of course, that's assuming all other qualifications have been satisfied. To better understand the look-back, allow me to offer another example. Let's say in January 2009, Grammy wins $1.5 million in the lottery. She takes the cash rather than the annuity. After taxes, she receives $900,000. Being a generous person, Grammy gives $100,000 each to her 3 children and $100,000 each to her 5 grandchildren. She keeps $100,000 for herself. Grammy needs nursing home care in February 2012. At that time, she has $20,000 in the bank. As the distribution of gifts were made after the Deficit Reduction Act was enacted, a 60-month look-back period applies. Since Grammy did not satisfy the 60-month look-back, she's deemed to have made disqualifying transfers in the amount of $800,000. In addition, Grammy has excess assets of $18,000. This is the difference between the $20,000 she has in the bank and the $2,000 allowed by Medicaid. According to information published online, the average daily cost of nursing home care in Massachusetts was $279, or about $10,155 a year. This results in a substantial penalty period. However, if Grammy did not need nursing home care until February 2014, none of the transfers would be a problem. This fact highlights the importance of advanced planning to become eligible for Medicaid. Sometimes the planning is done with the intention to wait out the look-back period. In so doing, the plan assures that money will be available to pay for care in a nursing home until the look-back period expires. Although most people believe that the biggest change under the Deficit and Reduction Act was the increase in the look-back period from 36 months to 60 months, actually the more significant change relates to when the penalty period begins to run. The penalty period is the amount of time during which the eligibility for benefits will be delayed as a result of making disqualifying transfers. Under the Deficit and Reduction Act, all gifts and other transfers made within 5 years of applying are treated the same. That is, gifts are calculated as if they were made on the day the application was filed. All gifts are added together and the total is used to calculate the penalty as of the day the person applies for Medicaid. For that reason, it is dangerous for any older adult, other than those with long-term care insurance and/or with sufficient wealth to pay for nursing home care out of pocket for at least 5 years, to make any sort of gifts or contributions, because one never knows when an age-related illness or disability may strike, requiring long-term nursing home care. The definition of a transfer was made intentionally broad. This was done to avoid loopholes in determining what transactions are subject to the transfer penalties. The definition includes not only the obvious direct gifts of money, but also less obvious things like gifts of property, selling something for less than what it's worth, placing assets into a trust, or forgiving a debt. People who think they can successfully evade the rules by making gifts in cash are usually in for a rude awakening. An awakening that appears during the Medicaid application process when the caseworker asks for and carefully reviews bank account records. If the caseworker sees a significant change in financial habits, that activity will raise a presumption of gifts subject to penalty. These penalties will be assessed unless the person who applies can come up with proof that the cash was applied to something other than gifts. When it comes to adding a name to a bank account, people are often confused as to whether that constitutes a transfer under Medicaid. This is how that works. When one person adds another's name to a bank account, Medicaid considers that no transfer has occurred yet. That is because the money is still treated as being owned 100% by the original account owner. The transfer doesn't occur until the money is taken out, and at that point, it doesn't matter if the original account owner participated in or even knew about it being taken out. For example, let's say that when Dad died 12 years ago, Mom put $60,000 into her savings account and added her 2 children's names to the account. Now Mom is in a nursing home and her children each withdraws their 1/3 or $20,000 each from the account. At the time of the withdrawal by the 2 children, Medicaid treats that transaction as Mom making $40,000 in transfers, and transfer penalties may be assessed accordingly. However, a different result ensues in real estate. Let's say that on that same day 12 years ago, Mom added her 2 children's names to the title to her home. As to real estate, that transaction completed the transfer. The children can now each claim their separate interests, and Mom will be treated as owning only a 1/3 interest in the property. For many people, their home represents their largest asset. Can it be protected? The short answer is, it depends. The home is protected so long as it's occupied by the community spouse, or by a child under 21, or by a dependent who is blind or totally and permanently disabled. However, once such a person no longer resides in the house, then it loses its protected status. Also, a house can be protected by transferring it to another person or an irrevocable income-only trust at least 60 months prior to an application for Medicaid. Also, the home is protected if there is an intent to return. What if a person has the intent to return but never does return? Simply put, it is subject to a Medicaid lien. A second home is a countable asset and is available to pay for health care. Protecting the home requires a transfer at least 60 months prior to an application for Medicaid. If one spouse needs nursing home care while the other remains in the community, special rules apply. The spouse remaining in the community is called the community spouse. under the 2013-2014 Massachusetts regulations, a spouse living in the community is entitled to keep the first of $117,240. This is called the Community Spouse Resource Allowance. As regards income, all sources of income, including pensions, Social Security, annuities, and rents, less certain deductions, must be paid to the nursing home to defray the cost of care. MassHealth allows certain deductions from income. For example, a person who lives in a nursing home and has qualified for MassHealth benefits to pay for his or her care may keep $72.80 per month as a personal needs allowance to pay for items that are not covered by MassHealth. The MassHealth recipient may also keep the income needed to pay for any uncovered medical costs, which includes premiums for his or her existing supplemental health insurance policies. Also, in the case of a married applicant, it allows a deduction for an allowance to the spouse that continues to live at home. This allowance is called the Minimum Monthly Maintenance Needs Allowance, and in 2013-2014 is $1,939 per month. If the community spouse's own income is below $1,939, the community spouse is allowed to divert income from the institutionalized spouse to get up to that amount. If the community spouse's housing costs are such that the spousal needs allowance of $1,939 a month is inadequate, a request for additional deduction from the institutionalized spouse's income can be made. However, MassHealth has an upper limit on the allowance paid to the community spouse. That upper limit is called the Maximum Monthly Maintenance Needs Allowance. This upper limit can be increased if the community spouse shows exceptional circumstances. All remaining income of the applicant is required to be paid to the nursing home. This payment is known as the patient paid amount. Medicaid then pays the balance of the applicant's care costs. If the nursing home resident is married, the spouse is entitled to keep all of his or her monthly income from all sources, regardless of the amount. As regards countable assets, planning needs to be accomplished to either take advantage of lien avoidance techniques or convert them into non-countable assets. An example of a lien avoidance technique is the child 2-year caretaker provision. This is how it works. If a child lived in the home with the older adult for at least 2 consecutive years immediately before institutionalization and provided care to the older adult, which permitted the older adult to reside at home rather than in the institution, then a transfer of the home to the caretaker is permitted. In other words, if the caregiver delayed the need for institutional care, a transfer can be made to the caretaker child without a look back. This means the transfer is effective immediately. To review, Medicaid is only available so long as the patient meets both the Medicaid medical and financial qualification requirements. Therefore, people with savings have difficult decisions to make. They can pay out of pocket for nursing home care or purchase an expensive long-term care insurance policy or give away their assets at least 5 years prior to requiring long-term care in a nursing home. To varying degrees, each of these options has its pros and cons and results in either depletion or a loss of control of savings. Preserving assets requires engaging in advanced planning. It also requires following the asset transfer rules, rules that can be a minefield for the uninformed. There is no doubt that you limit your planning options by waiting until you're in a crisis mode. Therefore, asset protection planning should not be deferred. As I mentioned earlier, the Medicaid regulations represent a complex and often confusing set of rules. Therefore, any gifts or transfers of property made by any senior, other than under the guidance and direction of a competent elder law attorney, can cause major problems if that person later needs nursing home care. With good asset protection, a family can benefit tremendously by engaging in proper planning sooner rather than later. Now I want to comment about filial responsibility laws. These are laws requiring children to be legally responsible to support their parents. Such laws vary from state to state. Massachusetts enacted a filial responsibility statute. It can be found in Chapter 273, Section 20 of the Massachusetts General Laws. Generally speaking, in a state having filial responsibility laws, a nursing home may seek reimbursement from the resident's children, as these laws hold adult children responsible for financial support of indigent parents, and in some cases, their medical and nursing home costs. Typically, filial responsibility laws aren't enforced unless your parent has to accept financial support from the government or incurs a nursing home or other medical bill that he or she has no possibility of paying. If your parent has no financial resources, you might be expected to pay for that care. In states with filial responsibility laws, the nursing home, hospital, government, or a third party may be able to file a lawsuit against the child. In so doing, these third parties would seek a judgment that would obligate the child to pay his parent's bill. Most state laws specify that your parent must be indigent before the court will rule in favor of a filial responsibility lawsuit. The Massachusetts law is more specific, stating that the parent must be destitute by reason of old age, infirmity, or illness, and is unable to support and maintain himself. The penalty under the Massachusetts statute includes a fine and a jail sentence. Other states may allow garnishment of wages or a lien against the child's property. At this juncture, there are some important points for me to make regarding filial responsibility laws. First, a filial responsibility law is unlikely to hold a child responsible who is struggling financially. Second, a filial responsibility law is unlikely to hold a child responsible who is paying significant costs for his own child, such as college tuition. Also, if your parent abused you or abandoned you as a child, the Massachusetts law allows that the parent is undeserving of your financial support. Lastly, the filial responsibility laws do not apply to an older adult who has gifted assets and satisfied the 5-year look-back. Therefore, one protection is to meet with an elder law attorney and develop a plan that would comply with the Medicaid regulations and assist a parent in qualifying for Medicaid while protecting assets. In light of the filial responsibility laws, adult children have the responsibility to clarify their parents' financial matters. In closing, the essential lesson here is don't procrastinate. Ensure your affairs and those of your parents are in order. Seek professional assistance, as the process of planning to qualify for Medicaid can be a minefield for the uninformed. Doing so will create comfort as well as peace of mind. The trick is to live for today and be prepared for tomorrow. Instead of worrying about tomorrow, today put in place good and thoughtful plans addressing issues surrounding your estate, finances, lifestyle issues, potential future disability, and anticipated future needs. In so doing, you can then go about the business of enjoying life each and every day. That is our show for this segment of Your Money, Your Life. My name is Attorney Ramsey Bahrawy, and as usual, thank you for watching.